The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 977, coming to you on Monday the 6th of July 2020. On this program, I will speak to you on the topic, A Will Must Be Voluntary. And before getting into the topic, as usual, my condolences go out to all those families which have suffered recent bereavements. I go into the topic without any further commentary or preliminaries. A will must be voluntary. As you know, voluntary means of one's own free will. It must not be forced. A person should not be pressured into making a will or into putting specific clauses into a will to favor the person who is applying the pressure or to favor the relations of the person who is putting the pressure. In other words, when a person called in now a testator gets ready to make his or her last will and testament, then whatever goes into that will should come from the free will of the person. Perhaps that's why a will is called a will. Too often, the elderly are vulnerable to pressure. That is, they are in a position where they are dependent on somebody and they feel a sense of obligation that they have to leave something for the person. Nothing is wrong with that generally. If an elderly person is being cared for by a faithful caretaker, nothing is wrong with the elderly person saying, look, when I die, I want to leave so-and-so for my faithful caretaker. But it surely must arouse suspicion if what the elderly person wants to leave for his or her caretaker is house and land, especially the dwelling house in which the elderly person lives. Unless the elderly person has no other relations, and the closest person to him or her is the caretaker. But where a caretaker brings an elderly person into a lawyer's office or invites a lawyer home to see an elderly person who is bedridden or who is not mobile, and is told, well, the elderly person is leaving this property for me. And the me means the caretaker. The lawyer must get suspicious and ought to ask a number of questions to see what other relatives the elderly person has, and to try to find out if the elderly person came to the decision to leave his or her property to the caretaker of his or her own free will, or whether they felt an overwhelming sense of obligation. They feel it can look bad if they ain't leave it for the person. So lawyers have to be extremely careful in situations where what the elderly person wants to put in the will appears to be totally disproportionate. In other words, something is wrong. And lawyers, over the years, as they get more experience, would develop a feeling that something is wrong. Similarly, if an elderly person has several children and grandchildren and great-grand, and one of those children brings the elderly person to a lawyer's office and say, "Oh, I've brought my father here, he wants to make a will." And when the elderly person explains to the lawyer what he or she wants to put in the will, the lawyer would become suspicious if the person says, "I want to leave my property to this daughter or this son who has brought me here." The lawyer is entitled to ask him or her questions as to why he or she is leaving the property to that person and that person alone. Now, some lawyers, including myself, have a practice that if an elderly person is brought to my office for the purpose of having a will made, I normally do not let the people who has brought the elderly person into my office to hear what the elderly person is saying to me or what I'm saying to the elderly person. The relative who has brought him or her is invited to remain in the waiting room, and I have to question the elderly person and satisfy myself that what the person wants to put in the will is what they want. I mean, it's not what I want, it's what the person wants. And I satisfy myself that, okay, it is not what I would have done, but it's not my property. I'm not the one making the will. That is his or her wish, and so on. But if the person appears to have been reacting under pressure, then I would ask a lot of questions and satisfy myself as to what is going on. You have the case where an elderly person has a property in which he or she lives. Person has a number of children, some are abroad. Some are in St. Vincent and Grenadines, living in various places, Kingstown, Chateaubriand, Leo, Connery, whatever. The siblings may not get along. Or you may have one of the siblings who is very cravenous and wants to get the bulk of the estate of the father or mother for himself or herself. And you know, envy jealousy, strife. They are things we encountered in the Bible from the beginning of time. According to the Bible, the first murder was committed by a brother killing another brother over jealousy because of the way the Lord reacted to their several offerings. Remember the story of Cain rising up against his brother Abel and slaying him? And when the Lord is questioning him, he has the pompousness to ask the Lord, am I my brother's keeper? With his freshness. Well, those attitudes haven't gone out. They are still prevalent up to today. You still have people who ought to be living in a loving manner, with fairness in the front of their minds. I said ought to. But very often the reality is that one person wants to get more than his or her proper share. Now, there are times when one person has been the one to look after the parent through thick and thin, while the other siblings don't even bother to contribute to the welfare of the parent. Some of them go away and they have a good job, but they don't look back. They don't know how the elderly person is eating, or how they're getting by with their medicines. So there are cases where it is justified for the one who has taken care of the mother or father to receive the bulk of what the mother or father leaves when the mother or father dies. Fair enough. So allowance has to be made for that sort of situation. But at the end of the day, what a person instructs a lawyer to put in a will should be the result of the person's own decision making and not a reaction to constant pressure and nagging and harassment. You know, sometimes the old people say, oh Lord, she worrying out my soul case. And out of frustration, they say, all right, you want so-and-so? I will give you so-and-so. Here, take them. Very often, when a person dies testate, that is, the person has made a will, it is normally too late to raise questions as to whether the will was a fair reflection of the testator's own genuine intentions, or whether the dispositions in the will, the things given out in the will, were induced by pressure. The law has a phrase for pressure. It's called undue influence. That's the proper legal terminology. But I will use the understandable term, pressure. And people can pressurize an elderly person in all sorts of ways. Blackmail, deprivation of food, See you daddy, if you ain't left sons so give me not give you. There's some people like that. Now the law requires that a will be a voluntary document. Both the idea of making a will and what is put in the will by way of gifts, which the law calls bequests to this or that beneficiaries. So that where there is reasonable suspicion that the instructions given by an elderly person are forced, then the lawyer should step in and have a discussion. Not just with the elderly person, but with whoever brought the person to the lawyer's office. Excuse me. Now, these concepts are important in places like St. Vincent and the Grenadines, which have the old-time philosophy based on the notion of what is called freedom of testamentary disposition. I'll break that down for you as usual. Testamentary means of or concerning or relating to a will. Disposition means what is given to various people by the will. Therefore, in St. Vincent and the Grenadines, once something belongs to somebody, that person is perfectly free to leave it in his or her will to whomsoever he chooses. Note, but that choice must be a free choice, not one based on pressure or threats. In some other countries, even some in the Caribbean, you can challenge a will if you are a close relative of the deceased person who has made the will, on the ground that the deceased person did not put your name in the will or had your name but didn't give you enough. You can challenge a will in Barbados, Trinidad and Tobago, Jamaica, and some of the other territories as a dependent whose expectations were unreasonably frustrated by not getting from the will that which that dependent ought in justice to have received. So that where a married person makes a will, leaves out the spouse, and gives away property to others except the spouse in those countries which have those special family provisions in their laws, spouse can go to court and challenge the will and say, my deceased spouse ought to have left so and so for me and did not. And I want the court, I want the judge to give me what, in all fairness, I ought to have received from the estate of the deceased person. And if the evidence is compelling, the judge has the authority to change the will and to give to the person who is complaining that which the person ought to have received as a matter of justice. Not in St. Vincent and the Grenadines, my friend. No judge can give you what you didn't get in a will on the ground that the deceased person had no good reason to leave you out of the will, or to only give you a little bit. I have seen at least one will made in the old time days where a husband left his wife a glass of water and gave his property to other relatives. Now, that giving of the glass of water was merely symbolic, but there is nothing his spouse could do. Once the deceased person owned that which the deceased person purported to give away in the will. Not in St. Vincent and Grenadines. You could challenge it in England and Canada and those other Caribbean territories I've mentioned, but not here. Here, once something belongs to you, if this is yours, you are free to leave it for whoever you want. You can give it to charity. Nobody can tell you what to do with your own property here in St. Vincent and Grenadines. And therefore it is important that when a will is made, it is a fair and just reflection of what the testator really, or testatrix, really wanted to happen to his or her property when he or she dies. There's an old witticism. You know, there's a saying, where there is a will, there's a way. Well, the cynical version of that is, where there is a will, there would be anxious relatives waiting to see whose name is in the will. But the making of a will is a serious responsibility in St. Vincent, given that you can't challenge your will here on grounds of insufficient provision for yourself. No. I didn't say you cannot challenge a will in St. Vincent and the Grenadines for certain reasons. You know, you can challenge a will in this country if you can prove that the will is fraudulent, or that the testator was not in his or her right mind when he or she purported to make the will, or that the will was not properly witnessed by at least two witnesses signing together in the presence of the testator, and so on. There are grounds on which in St. Vincent and the Grenadines a will can be challenged, but not on the ground that you were left out of the will, or that what you got from the will was too small, and others who didn't deserve a bigger share got a much bigger share than you did. Not on those grounds. A will can be a beautiful expression of the esteem in which the testator held certain members of his or her family, or even certain friends. But a will can also be used as an instrument of oppression if it doesn't flow from the genuine desires of the elderly person. And don't forget, as people get down in age, they sometimes have mental problems. They may not be serious enough to have them institutionalized, but they may have a little one or two mental problems. They may not be thinking right. And therefore, care has to be taken, especially by lawyers, when asked to prepare a will for an elderly person. The lawyer has to make sure that the elderly person was not suffering from any impairment of mind or disillusioned or delusional or any other problems associated with failing mental capacities. All right. So I hope you understand a little more about the requirement that the law insists. The fundamental requirement is that the last will and the testament of a person should be a fair, honest, and accurate representation of what that person wanted to happen to that person's estate when that person should die. All right? Fascinating topic. Well, that is all from this program of The Law and You, program number 977. I look forward to being of further service to you next week, Monday DV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls. Take care of yourself in these COVID-infested days, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.